Yes, Ms. Rogers.
I hope to be no longer than 30, perhaps 40 minutes, but
Right.
I'm aiming at 30.
So we were looking at the schedule to Mr. Spendlove's third witness statement.
Yes. If the court's read it, I wasn't going to
No, fine.
just repeat it because it
Yeah.
says what it says.
Yes.
And what I say about the categories, which one can see what they are, what the contents are by reference to the summary, correspondence with trustees in bankruptcy.
Yes.
We're saying personal, private, confidential for each of those types of communications. And so that's what we're saying about effectively everything that's in the 4849 categories. Can I was just going to start, just to get it out of the way, just to go back to the passwords point, if I may,
Passwords, yes.
for a moment. And this is just to, this is the account that Mrs. Brake set up when she set up the Fast Host account, which she says is 2009. She was the only person with the passwords, with the exception of Andy Allen, who worked for the computing system. They were doing IT services. And as the court knows, it's not in the file, but it's referred to by the judge. And there's a non-disclosure agreement, a confidentiality agreement between Mr. Allen through his Allen Computing Services of computing technology and Mrs. Brake. So anyway, that's how it comes about. Throughout, she says, the password to the Fast Host account was only known to her and to Andy.
Was there evidence about this, or are you telling us this fresh?
There was evidence about it. I'm telling you, if I may, saying what I'm instructing the position is, and I'll refer to a passage of the judgment in a moment.
Only known to her and Andy.
And then, so in order to get onto Fast Host at all, you had to have the gateway password, and then there were separate passwords in relation to separate accounts, including inquiries. Again, Mrs. Brake is the person who has the access to it.
So to get to the inquiries account, you're saying there were two passwords, were there?
An account password and a...
The Fast Host account, which is the host, the domain. I'm sure I'm using the wrong word, but
the account and the address.
Yes.
So there's an account password and an address password.
Yes, for the address and the password for the address, whether you call that an account or not. But to get to the inquiries at email, you needed to have a password to get into.
You need two passwords. And if you went to the other accounts that Mrs. Brake had, other account.
The same, I think, was the case for all of them, but the Allo and Andy similarly the case.
Just so the court is aware, that evidence was not before the court.
Well,
that is what?
That evidence was not before the court below, and is definitely challenged.
Well,
it's challenged. Okay.
I'll just that's the other factor that for sure that Mr. Windus and Ms. Holt had for short periods access to the email account, i.e. the inquiries account, on their computer, but they had it in a way that they weren't given the password. So they just are given access to the account through a computer so that they can use it and access it. But that's because they're given the access to it that way.
This seems to go beyond the judge's finding.
Well, the judge finds out, and Mr. Day drew my attention to, and I was just about to take the court to J100.
Yeah. 100 is a paragraph number or page.
Oh, sorry. No, it's sorry. 110 is the paragraph. Page 163 is the page. Tab 7 is the tab.
110.
Yes. So Windus and Holt both use the account.
Yes.
And then they use it. That's the circumstances. In other words, they use it without having the password to it. And what's said at the last lines of this is in May 2017, Mrs. Brake authorised Andrew Allen to provide Simon Windus with the password for the account with the address allo at.
So where does the judge find they didn't have the password to the inquiries account?
I'm not suggesting the judge found that they didn't have the password. I was asked what the position was, which I checked. The finding that he has here, the judge finds that
The judge's finding is that Windus and Holt used it.
had used it.
It doesn't, I think, say anything about passwords.
No, but that's why I draw the attention to the password in the last lines of 110.
Well, that may well be, but that's because the allo at account is Mrs. Brake's private account.
I'm drawing the distinction between having the password to and using. Well, that's all. I'm not. All I can tell you is what I'm instructed as the position, and I draw your attention to the paragraph of the judgment where, quite rightly, that's what the judge found.
Right.
If there's more, I will of course check.
There's one other reference.
Oh, thank you.
That I should give. It's on page 198. That's the last sentence of paragraph 231.
Yes, so Mr. Windus had unrestricted access. Yeah.
So
Were the private accounts Ali and Andy set up at the same time as inquiries?
I'm told no.
You're told no.
Let
me ask the proper question. I should have asked. What did the judge find about that?
The judge finds that accounts are set up in August 2015.
At the same time.
There'd been previous.
Forgive me, that's why I'm asking about this. The architecture of the structure was that there was an inquiries account and an Ali account and an Andy account. That's the architecture. There may have been more, I forgot.
Simon, Rebecca and Saffron at various points, but
It's paragraph 77 on page 154.
So, a simple-minded soul coming to the fresh might say, well, weren't Andy and Allo private accounts and the inquiry is a business account?
primarily a business account. That's not disputed. It's used for the name. It's inquiries. It's business inquiries, but that doesn't mean that it isn't used for private purposes as well. It was so used. The Guy parties knew it was so used, and that's why the question arises of.
But if one's looking at the overall arrangements, and you stressed IT policy, contract terms, and so forth, might it be of significance that the employer has provided the employee with two different accounts, one of which is, so to speak, marked private, and the other one is not?
It's a factor.
Yeah.
But it doesn't mean that
it's not decisive.
It's not decisive.
No.
It doesn't. And it doesn't
you
mean
accept
that,
it is a factor that,
of course,
to take into account.
This is it is the inquiries account, and as we know, the 30. I've lost my own figures now, but the over 30,000 emails are business emails, AEL business emails, accepted by us so to be. But that doesn't mean that that's decisive in relation to other communications, which, to the knowledge of both sides, private communications, are being used.
I suppose there was no analysis done of the use of the Allo account, was there, or the
Don't
Andy
believe so.
account?
Don't believe so. And just on that, I understand that although they're being destroyed, I think that there are the odd email from Allo account, it's possibly from the Andy, but certainly from Allo, which are still in existence and cropping up in the proceedings in some context. I don't think it matters for present purposes, but it's not that they no longer exist. But focusing on where we are, just so to. I was just going to turn next before going. There's a small number of points that I want to make in relation to the appeal. But I was asked before the adjournment if we're abandoning any part of the appeal, to which the short answer is no. We're not abandoning anything. But we're focusing on the heart of the case, for obvious reasons. If we fail at the heart of the case, the rest is not actually going to matter. And that's why we're focusing on the 5511 and the 4849. And just while we're on that, the point about the 5511, they were destroyed after the trial, we're told, but that, of course, doesn't mean that no use was made beforehand. And there's one document, just by way of example, which is the letter of wishes. The details of my client's medical condition may be private, but the fact that she's has a serious number of medical conditions is on the public record. And there's a letter of wishes that is written, which is on the email account. And I understand that is among the emails that were disclosed by Dr. Guy to, I believe, Mrs. Bream, who was the ex-partner. Now, it's obviously a very private document.
Disclosed to Mrs.
Bream.
Bream.
Who's the
As in the fish.
No, it's B-R-E-H-M-E.
Thank you.
And so obviously the question of whether it was, and if so, whether there was any reason to do it, and if it wasn't, there's no good reason, that the amount of compensation that should follow from that is obviously massive. In other words, what all I'm saying is the fact that the documents were being destroyed means no injunctive relief, but it's not the end of the question as to whether or not there was use made of the 5511. And obviously the 4849 is still live in contention. The 11797, I think I was asked if they were all between the parties. The answer, and I think I said they probably were, but the fact, then they're either between the parties or they're sent by one of my clients acting as the agent for the Guy party. So in other words, it's a Guy party email. So that's the 11797 category, which is not, as I say, not at the heart of the appeal, but the fact that they are available to both parties doesn't mean you can do anything you like with them. I mean, that's a separate issue. Down the line. And as for the 3149, as I say, the question of whether they were mischaracterised or how many of them were mischaracterised, if they were mischaracterised, again, that wasn't exhaustively analysed before the judge in the circumstances where, as I say, the documents had been produced very shortly before trial, and a number of documents were put together. I'm told that there was a clip of 167 documents which were put in the course of the proceedings, but not put to individual witnesses. But that is not at the forefront of the appeal. The forefront of the appeal, as I say, is the 4849 and the 5511. But as to the 3149, there's the judge found we haven't proved that they were not business emails. Just going back to the two points I want to go back to, and then I'll move on, and there are 3 points after that. So going back to the question of introducing wrongdoing at stage 1, as I've said, this is we say the judge was right in paragraph 40 of the subsidiary judgment, the preliminary issue. We've discussed the question of JR 38. And I wasn't going to take the court to Murray. It's accepted by both sides that Murray is the key with the list of factors, and activity is in there. But just to mention this to the court as well, should it be of any interest, our researchers had produced I think one case in which at trial Mr. Justice Nichol had found that the misconduct was a stage 1 factor. And it's a case called Axon, A-X-O-N. I think it's the Ministry of Defence. I've got, sorry, I can provide the reference.
I've seen reference to that somewhere.
Yes. Anyway, Axon is a case in which it was the commander of a warship had engaged in some misconduct, and the question was what could be published and so forth. And the judge has a whole list of factors. I think they're lettered A through to O in paragraph 64 of his judgment. And paragraph 64E, he says that the wrongdoing was a factor not just at stage 2 but also at stage 1.
Have you got a reference to that, Axon?
I have.
Is it a case that we need to read?
It depends. Need? I think our position on this is that, that of course, that that iniquity, if it's an issue, whether it's stage 1 or stage 2, means the judge can't reach the findings he has. But if the court, in that context, of course the court is interested, but whether it's particularly germane to the appeal, we can certainly provide copies of Asplin and for
You've
that
got a reference for it.
JR 38. 2016. It's reported, isn't it? Yeah.
2016 EWHC.
Whoops, sorry. EWHC 787QB, Mr. Justice Nichol.
787 QB.
And it's reported in the EMLR 2016. They do it by case number. It's case number 20 in 2016.
20.
And it's page
Okay,
392.
thank you.
As I say, it's that reference in paragraph 64E and F, where Justice Nichol, who was of course dealing with all issues at the same time,
Yes.
treats it in the context of that case as being a stage 1. It's a point not without interest, but so far as the outcome of this case is concerned, we say it makes no difference overall, because either way it means the judge can't redefine it.
Right.
Second point is this, that one of the points which has been obviously concerning the court is the question of what can an employer do. And it's important, of course, to bear in mind that on the facts of this case, this wasn't a case where the defendant said we're investigating some kind of wrongdoing. That's why they're looking. Quite the opposite. They're saying all we're trying to do is get rid of your material from the account so that we can get on with the business. That's what they're saying about it. And Dr. Guy's evidence. This is recorded in the judgment. Is that he looks at the material in January. The dismissal is November 19. Then some months later, the lawyers have access. So some months later, he has a look and stumbles. Sorry, 136. And he has a look at the material. He's not looking. He's not looking for wrongdoing, but as he says, and as the judge records at 136 in the judgment, page 169, when he looks, I stumbled across a number of emails.
Sorry, just a minute. 136. Yes. Yes.
He's looking at the inquiries account in order to familiarise himself with other aspects of the business. So, and then, as he put it, and I accept, he stumbles across a number of emails that corroborate entirely what I've been told by Mr. Bartley.
What has he been told by Mr. Bartley? This is 133.
My lord will find it at 133.
Yeah.
And that is an allegation it's the iniquity, one part of the wrongdoing allegations which are made. Denied, made, not being tried by, not being determined by the judge. So in a sense, if it's reassurance to the court, this is not a case where, if there is a reasonable expectation of privacy, it impedes the normal disciplinary processes or the investigative processes. That wasn't what was going on. There had been a termination of employment, and it was a fact that the complaint was being made about the emails on the account, and which were claimed to be private. In terms of so three points which I was going to deal with. The only the biggest one is in relation to the issues at trial and the case of Immerman. And first of all, just to turn to the issues as they were formulated for the trial, which it's in court, the supplemental file number 2, first supplemental file.
These are what
Tab 20.
these were quoted by the judge.
Yes.
And then in the end of his judgment, he answers the questions.
He does. So he quotes them, I think, in 199 and answers them in 301 summary form.
Yeah, he doesn't quote issue 12 in full.
He doesn't quote issue 12 in full, and it's only issue 12 that I was going to ask the court to look at in this form. Obviously, one can see what the issue is, and these are, if I emphasise, these are agreed issues.
Where are you in the papers?
Sorry, it's tab 20.
In
Supplemental file 1 or file number 2. I've got them numbered 1, 2, 3. It's the first supplemental file.
Yeah, page 223.
Page 223. This is the second page of the issues, and the categories there is the way it was agreed to proceed. And we say that looking at the first 10 categories, all of those are emails which fall into our claim category, i.e. personal, private, confidential. Friends and family, legal advisors, accountants, school, partnership, official receiver, partnership dispute, Darcy, and then Mrs. Foster, who was Sarafina Properties, who previously owned the estate, the farm. Then the last categories are what one sees, the 11 through 16 seem to me to be the categories that really fit into the third category, the 11,000 odd emails, where they're either between the parties or on behalf of one of the parties. What's curious about this is, as I say, these are agreed categories. There is an overlap between the way they're presented here and the way they're presented in Spend Love 3. Because there are friends and family, there's medical, the accountants, and so on. But either way, we say in a case like this, with the number of emails that there were, proceeding by category is the way to go. Because in a sense, one can see, if one's having a communication with one's doctor, where the doctor is saying, have you seen this film, have a look at it, you might be able to say, well, look, that's either de minimis or trivial or off the scale. But on the face of it, unless it's shown otherwise, we say all of these are manifestly private, personal, confidential.
1 to 10.
Sorry?
1 to
1
10.
to 10. And I say about 11 to 16 that they are in the category, they're the shared communication. So they're still, that you can't do what you like with them. We're not saying you can't see those because you've already got them or they're on your behalf. So this is the distinction between 1 to 10 is you should never see these that have nothing to do with you. And the other ones which are, you can see these, but that doesn't mean you're free to do what you like with them, you put them on publish them to the world. But it's obviously bizarre to say you can't look at them because you've got them or they're sent on your behalf.
So are you saying that in categories 1 to 10, the judge should have reached final decisions on whether they were or weren't private without seeing any of the emails within those categories?
Well, yes.
Just by looking at the categories?
Yeah.
You can say correspondence with friends and family, that's private. Don't need to see any of it.
If it's said, for some reason, despite the fact it's in that area, it's the correspondence for Article 8 purposes, it's the kind of thing which is treated as confidential. Medics, schools, accountants, all of the kind of things, financial, personal, medical, all of those types of communications are the types of communications which are routinely personal, private and confidential. Now, of course, there could be cases where somebody said, well, yes, but in this case it isn't. Or you could say, in this case we need it for misconduct. So that's the second test.
So it's if you like, a reverse burden of proof.
Yes. Get into the
you
area.
say that having categorised them in this way,
by agreement,
they are private unless shown not to be.
yes. And the curious thing is, and I don't know what the answer is, but what, in a sense, the Spend Love 3 categories aren't done by reference to issue 12. I mean, maybe that issue 12 wasn't finally agreed until too late, but Spend Love 3, in fact, must be after this because Spend Love 3 is so close to trial. But be that as it may, they are the similar categories. We see the medical, social media appears, friends and family are there. So there isn't a dispute, in other words, that there are emails in these categories. And in fact, the opening submissions for trials say that it's accepted that there are emails in these categories in the account. So, and it would be illogical to have agreed those issues unless these were the kind of things that were in the account.
Yeah.
So that's where issue 12 is now, and they drop away. The judge doesn't ever quote those issues. He talks about issue 12 in an entirely general way. And this is one of our criticisms of it, is that the trial is set up to be dealt with by virtue to that, and then it isn't.
Yeah.
And in terms of whether it's right to proceed in this way, I was going to ask the court to look at Immerman, which is in the authorities file at tab 9, which means it's the first file, I think.
Yes.
And just to say this by way of introduction, it was a pretty extreme case on the facts. It's Mrs. and the parties the wrong way around. The White brothers get access to husband's emails and take away on 9 separate occasions from his office. So the court was pretty troubled with what had gone on. But
You want paragraph 78?
I was going to start earlier, I'm afraid, 66.
Right. You're going to start at
66.
66.
And simply, I started partway through 66. Lord Phillips is observing there are dangers in conflating privacy and law of confidence. I agree with that, and we're not. I should emphasise we are not seeking to conflate the two. We're focusing on misuse of private information because that's the one that, in a sense, the heart of the case. But what it's worth noting here, we appreciate they're separate and distinct elements, but the court notes here, the touchstone suggested by Lord Nichols in Campbell's case, that's the Naomi Campbell case, which was of course the start of the misuse of private information tort as it became. Namely, whether the claimant has a reasonable expectation of privacy in respect of information issue is, as it seems to us, a good test to apply when considering whether a claim for confidence is well-founded. So you don't conflate them. But all of this is why I say that all of the points I've been making, seeking to make about reasonable expectation of privacy, which I'm not going to repeat under the breach of confidence head, but they're all relevant under that head because the touchstone is the same. So I was going to start at 66. Can I ask the court to read 66 through to 72? I mean, they are highlighted, so.
Right?
Yes, and just highlighting in the sense from 69, it's the essence of the right, as the court notes in 69, is that the right of confidentiality allows the person to choose whether, if so, to whom and on what terms, to reveal information which has the protection. It's the autonomy which is the heart, in a sense, of both of the causes of action. As 72 notes, if the defendant looks at a document to which he has no right of access, containing information confidential to the claimant. It's not. It would be surprising if the claimant couldn't get an injunction to stop the defendant repeating it if he threatened to do so. Now that's so, and it's so in essence, it's the access, it's the looking, it's the loss of autonomy, and then of course the further distribution is part of it. Two last references from this this case while we're on it. The paragraph which isn't highlighted is paragraph 76. It's over the page 278. And the court notes, it says, it's taken as read, communications which are concerned with an individual's private life, including his personal finances, personal business dealings, possibly other business dealings, are the stuff of personal confidentiality and are specifically covered by Article 8 of the Convention, which covers the right to respect for privacy and expressly mentions correspondence. Now, and so 76, those types of communications, individuals' private life, personal finances, personal medical business dealings, are exactly the kind of thing that are highlighted in the categories in Spend Love 3 in the non-business section. And then 78 to 79 are the highlighted ones. The judge mentions, I should say, the judge does mention this particular paragraph from Immerman at paragraph 166 of his judgment. So he does acknowledge this paragraph is there. It's on page 175, paragraph 166. And this is how you do it. Can I just ask the court to just to read that? It explains in a sense why one goes by way of category and not by way necessarily of individual document.
Sorry, which paragraph?
78, sorry. And over to 79.
Yes.
It's not about locks. It's not about locks and keys or
Yes, the
equivalent.
judge created that.
He does. But he quotes it, but then in a sense we say he doesn't carry it through on the facts of this case. That's precisely how it is in this case. The very last point from this case is in relation to the question of self-help. And in a sense, taking advantage of access to someone's private information for your own purposes or even for litigation is something that the court sets itself firmly against. It's paragraphs 116, 117. And this is, of course, in the context of the Hildebrand rules, which in a case which includes my Lord Baker, I'm reluctant to get into the nicest Hildebrand, but I don't know, so we don't need to, because this is the Court of Appeal dealing with Hildebrand on the back of White and Withers, exactly. And the reason that they go is because, as paragraph 117 makes clear, there was a difference of opinion in White and Withers, which is in the previous tab in the case. For some reason it's come as a transcript, but it is in fact a reported Court of Appeal case. But the relevant paragraphs are there if wanted. Lord Justice Ward had disagreed with Lord Justice Sedley and Wilson, but the court agrees with Lord Justice Ward that the Hildebrand rules can't be justified on any of the bases suggested, whether lawful excuse, self-help or public interest, or indeed any other basis. And then they point out that trespass and so on have no hint of any kind of defence of self-help. And at G, self-help has a narrow and jealously policed role to play, for example, in the form of the right in certain circumstances to abate a nuisance. But it's far too late to suggest that self-help should be extended into the territory we are concerned with. And then Sterling's statements about the access to the courts, which the courts are where you should go. You can't resort to self-help. So that's what we say. As I say, this isn't a case where it was asserted that they started to look at the account in order to find evidence of wrongdoing. But whether they started to do it for that purpose or then subsequently did it for that purpose, the courts have firmly set their face against self-help. You are not entitled to trespass into somebody's private correspondence, personal, confidential, private correspondence to help yourself.
So in that kind of litigation, you have to apply to court for some sort of disclosure order,
Yep.
and then you will be able to see somebody's private or confidential. You may be able to see
You may or
somebody's
may not.
private or confidential.
There's a whole raft of issues that then crop up. I mean, for example, in the field of legal professional privilege, which is in very exceptional circumstances, it can be broken into, but they're very limited because of the fundamental right of legal professional privilege, and then
So,
the question of what
if there is an employment dispute, you may be able to ask the employment tribunal to require disclosure of the employee's
personal
documents.
conceivably. But you can't take them yourself. And if they've left their if they've left their briefcase, handbag, or left here's the electronic equivalent. If they've left that in your office, you can't look at it, tempting as it may be.
I mean, would that be relevant to the assessment of any damages? Whether there was another means by which you could have got these documents legitimately, so that they were not the kind of documents that the claimant could keep secret forever. They could be released for this limited purpose to these particular parties.
Conceivably, but it's more likely in that sort of circumstance that the court would be saying, well, we're at the second stage, iniquities coming up, and saying, well, you don't have a cause of action because the interest that you have is outweighed by a countervailing interest. So you'd probably fail at liability if you've got that kind of case.
Well, is that right? I'm just thinking of ordinary civil litigation. If I allege some kind of wrongdoing on the part of my opponent, my counterparty, if you like, in civil litigation, that counterparty has got to disclose documents relevant to my allegation, whether it turns out to be well-founded or not. So I get the documents, I make of them what I can.
You can't found an action or a claim for damages on the disclosure of documents in the course of court proceedings.
No, I follow, but I'm just thinking about if I jump the gun and I get the documents without waiting for disclosure, you say, well, you can't use self-help. You've committed a tort, maybe I have, but wouldn't the damages reflect at least the possibility that by the ordinary processes of civil procedure, I would get exactly the same documents, but perhaps a month or two later?
It doesn't mean that you were right to do what you did.
You could argue it the other way, couldn't you? You could argue it the other way. You could argue it the other way.
Yeah.
But the more...
You could have done it and you didn't.
The
and
more,
it's even worse than
your point would be, wouldn't it, that given that self-help is not allowed in these circumstances, family courts say to and generally self-help is not allowed, all the more important to mark the importance of that. What are the damages designed to compensate for anyway? They're not compensation damages, are they?
They are. They have a number of elements.
Yeah.
I think Mr. Justice Mann is said to give the best account of that in Richard, which we've got in the files. It's endorsed in Gulati. He does it. 229 in Gulati, and it's approved by the Court of Appeal in Gulati. They set it out in paragraph 32. They're all in the file. So Mr. Justice Mann deals with the elements. And part of it is it's not vindication damages in the sense that have been outlawed by the courts, but there is an element of the loss of your autonomy over your information is something that the courts take into account. So obviously publication is one aspect if it's published, but actually to whom it goes and the impact on you, the distress, the nature of the information and so on. But if it helps...
Well, my Lord's point is, does the fact that the documents are disclosable in a lawful way undermine the insult to the autonomy? And what's your answer to that?
And it's not as though there are some sorts of cases where parties don't have access to lawyers, and people do things because they do things without thinking about the legal ramifications. That can't be said in this case. There are plenty of lawyers, and of course, by the time we've got a number, the number of sets of litigation in which, had it been necessary to go into access to documents, applications could have been made, and so on. But you can't self-help. You can't jump the gun. And the point that your lordship makes about that, of course, we make it in this case in relation to disclosure to the, in fact, he's the former trustee in bankruptcy, Mr. Swift. It said, oh well, he could have applied under section 366, I think it is, of the Insolvency Act. He could have applied under section 366, and then he'd have got them anyway. But the whole point is he didn't. And if he had applied under a court process, at least the court then has the opportunity to look at it. Perhaps it's the case in which.
Well, that was going to be one of my questions for you. So whether the trustee in bankruptcy made any difference. You say no, because he had a statutory power which he chose for one reason or another not to exercise.
Yes, exactly so. And this is why the law in so many different contexts provides for powers to bodies. It's not just the police. There are all sorts of regulatory and investigatory bodies in various different contexts who have powers to require people to produce information, even if it's private. And of course, disclosure is one aspect of that.
The fact you could have got a search warrant
doesn't mean you can break down the door and get it yourself. Process matters, and rights matter, and the fact that, you're not a jury. What I'm trying to get over is that the autonomy over your own information is something that's really important. And it's one thing for the court. You may not be happy if the court had ordered this material. May not have been happy about it. May have chanted and so on. It may, of course, have declined to order it. But the point that we're looking at is that they didn't have the chance. Mrs. Brake did not know what the Guy parties were doing with her information. The Guy parties know. The trustee in bankruptcy is one thing. The Guy parties know Mrs. Breen had a big falling out over the partnership dispute. And material is passed to her. The material that was passed was evidence put before the judge. There's a witness statement Dr. Guy swore. There's exhibits to it. Imagine the hurt of a letter of wishes going to a person. Anyway, those are the only points I was going to make about issue 12 and indeed on Immerman. And that just takes me to 2 points, which, if I may, I was just going to take very, very shortly indeed, which is simply to say that in relation to breach of confidence, we do take it very shortly in the skeleton, but we are not making the mistake of conflating the two. As I say, happily for the court, there isn't dispute about the elements of the causes of action for breach of confidence or misuse of private information. It's McKennitt and Murray on the one hand and Coco and Clark on the other. But we're not conflating them, and I've shown you, Lordship, that quotation from Immerman in relation to the don't conflate, but one is the touchstone for the other. And lastly, I was going to just say this about remedies and damages, or the use that was made and the damages which are assessed. I was simply going to say that really those are matters which are, if we're right about it, that the judge can't decide the case against us, that there are matters which have to go back to the judge in relation to back to a judge in relation to iniquity. Then in a sense, whether he got it right or wrong the first time doesn't matter. We say he got it wrong. I've not gone through the skeleton rigorously, but I do. What we say about it is there. But it's such a consequential issue for the court that unless the court wants me to go to any of those points, which I'll happily do, I don't think it's central, because they are points which will which are arising. They only arose for the judge as an alternative to his main decision. Yeah. So they'll only arise if we succeed on the appeal, and if it goes back, and if whoever decides the case takes a different view. If your lordships will forgive me for 1 minute, I'll just turn to see if there's anything that I've missed out. Unless there's anything more. Unless there's anything more from your lordships.
One question, if I may, Ms. Rogers. Could you look at Murray for a moment? Authorities Bundle 1, tab 6.
Yes.
Looking at paragraph 35 of the judgment of this court, where they derive the principles from Campbell, and say, the question is whether there's a reasonable expectation of privacy. It's an objective question, discussed in Campbell, All Hope emphasised the reasonable expectation was that of a person who's affected by the publicity, and said at 99, the question is what a reasonable person of ordinary sensibilities would feel if she was placed in the same position as the claimant and faced with the same publicity. And that seems to be what they think of as the right test.
Yes.
And I'm comparing that test with the judge's finding at paragraph 160, the last sentence of which says, in the restrictive contexts in which disclosures have been made, I consider that no reasonable person of ordinary sensibilities would be substantially offended. How does that feed into the equation, if at all?
Reading the judgment, there's no doubt that the judge had taken a dim view of Mrs. Brake on a number of matters. But because his approach it's not surprising that he wouldn't find it upsetting, because he found that there was nothing wrong with what had happened. So anything that she says about the impact on her is viewed through his eyes, that there was actually nothing wrong with this at all. And as I say, the impact, the autonomy, the question, the things that strike one about it. Providing highly personal, to use a neutral word, we'd say private and confidential, information to Mrs. Bream at all is something which we say is obviously highly offensive to a person in the position of the claimant, Mrs. Brake. Likewise, circumventing the court process by giving material to the trustee in bankruptcy. Likewise, looking at this stuff at all, letting a barrister, whether the barrister's wife adds much to it, letting lawyers pore over this stuff, providing stuff to a press agent, or it's not for publication, it's for briefing, providing stuff to a press agent are all matters in which we say if the judge finds that that is not offensive to a person of ordinary reasonable person of ordinary sensibilities, then that is within the category of decisions which is just plain
Wrong. No reasonable judge could reach that view. Yeah.
And I should say, although of course, I haven't dealt with the test on the appeal, Lord Justice Newgy was right, obviously, when he gave us permission, that we face a considerable hurdle. Yes, we do. But we say that looking in all the circumstances of this case, was this judge wrong? We say yes, he was.
Yeah. And the other point that comes out of Murray quite strongly is that whether there's a reasonable expectation of privacy is a question of fact.
Yes.
You accept that?
Yes.
So the appeal depends on overturning the judge's factual conclusions.
Yes, with the sense that what we would say is the legal error on the way through his view of the email account, Article 8 and Simpkin.
Yeah.
So it's not, there's a legal framework before you get to your question of fact.
Right. Yes, thank you very much. Yes, Mr. Sutcliffe.
My lord, my lady, can I start with the last matter raised by my Lord of Justice Lewison? This appeal seeks to challenge the trial judge's evaluation of the evidence. I know you're familiar with the authorities, but can I just ask you to look at Appeal Bundle 1, tab 5, which is the case of Brown, the Associated Press.
Sorry, appeal bundle.
No,
Appeal
Authorities Bundle.
Authorities Bundle 1,
Yeah.
tab 5. And if I can ask you to turn to page 102. Like this case, Brown was a case in which a judge's decision on reasonable expectations of privacy was challenged on appeal. And if I could ask you to look at paragraph 45 at the footer cap page,
Yeah.
in the judgment of the Master of the Rolls, and just read that to yourself. Paragraph 45, page 102.
Yes.
We also rely on the well-known passage from my Lord Justice Lewison's judgment in Phage, which for your note is at tab 10 in the same bundle, page 336 of the bundle, paragraph 114, and upon the recent and comprehensive statement of the principles in another decision of this court, Respondent, and you'll find that in Authorities Bundle 2, tab 14, and the passage that I rely on starts on page 484 at paragraph 68 with Mr. Pavlish's first submission. But and it goes right through to paragraph 79 on page 488. But for present purposes, can I just ask you to read only paragraph 76, which is at the top of page 487.
Yeah.
And the court can put that bundle away. In this case, the trial judge was not only within the ambit of conclusions which a judge could reasonably reach when he dismissed this claim, we submit he was obviously right to do so. There were no reasonable expectations of privacy or confidentiality in the inquiry's account. There's no gap in the logic of the trial judgment, no lack of consistency, no failure to take into account some material factor, no other flaw in the reasoning in the trial judgment, in the sprint rule sense, that will permit this court to interfere with the judge's evaluation of the evidence. The inquiry's account was a business email account owned by the third respondent, AEL. Its purpose was to deal with inquiries by actual and potential customers of AEL's wedding and accommodation business. There's no evidence that the first appellant, Mrs. Brake, was authorised by AEL to use the inquiry's account for anything other than the purpose for which it was created. Mrs. Brake received no assurances about any privacy that might be afforded to her when using that account for personal matters before or after she started to do so. The respondents accept, as indeed Dr. Guy accepted in his evidence, that employees can and do use work email accounts to send and receive personal correspondence. However, when they choose to do so, they reasonably understand that such correspondence will be less private and confidential than if they had used a personal email account of their own. Whether employees can, in law, assert any rights of confidence and privacy over personal correspondence in a work email account will depend on the particular circumstances and the evidence before the court. There is no bright line rule, one way or the other, as was conceded by my learned friend this morning. This is necessarily a multifactorial exercise. Each case turns on its facts, in other words, on the evidence before the court at trial. This case was an especially weak case for claiming rights of privacy and confidentiality for two reasons. First, the inquiry's account was not a work email account that existed for the dedicated use of one person. Instead, the inquiry's account was accessed and operated by AEL through 3 employees These were Mrs. Holt, who was also a director, and Mr. Winders, in addition to Mrs. Brake herself. At no time was Mrs. Brake the sole user of the account. Mrs. Holt was meant to be the sole user of the account for the first 6 months of trading, because Mrs. Brake was injuncted from working in the business. But for your note, that is paragraph 3 of the order of Sir William Blackburn of the 1st of July 2015, which you can find at Supplemental Bundle 1, tab 1, page 2. When that injunction expired in January 2016, Mrs. Holt and Mrs. Brake both used the inquiry's account until Mrs. Holt went on maternity leave, and Mr. Winders was then hired to cover Mrs. Holt's position. Nor was this Mrs. Brake's only email account. From 2015, AEL provided Mrs. Brake with a dedicated email account, allo@axnola, and throughout the period, Mrs. Brake also had her own personal email accounts, like Gmail, which were obviously more suitable for personal correspondence.
You say Mrs. Holt after the injunction expired, Mrs. Brake and Miss Holt used it together.
After the injunction expired, exactly, my lord. Yes.
Was there any evidence about Miss Holt using it for private purposes?
No. Indeed, the judge found to the contrary.
Yeah, the judge found
He found there was no evidence that either Mrs. Holt or Mr. Winders used the account for private purposes.
He made findings that neither of them did.
Yes.
He did, exactly.
But I mean, Miss Rogers says, well, look, you've only got to look at these categories. No matter where they're found, somebody's medical records are obviously private to them.
I'm going to deal with that
Right.
categories issue, because it's a discrete issue which I will definitely raise. We say that in those circumstances, Mrs. Brake, or any reasonable person in her position, must have known that the general inquiry's account lacked privacy and confidentiality. As the judge rightly asked at paragraph 242 of the judgment, and that's page 201 of the core bundle, and I quote, if others have access to the same email account as you, how can you expect that its contents should remain private to you alone? I call this the multiple users question, and that question has caused the appellant considerable difficulties throughout this litigation. The second point is this. As my Lord Justice Lewison said this morning, Article 8 protects respect for private correspondence, not private correspondence per se. The trial judge found as a fact that my clients, and I use his words, bent over backwards to allow Mrs. Brake to remove personal emails from the inquiry's account immediately after she was dismissed. That, for your note, is paragraph 125 of the judgment, at page 166. Again, as the judge found, those reasonable offers were refused by Mrs. Brake, unreasonably so. That's in the same paragraph. If that reasonable offer had been taken up, we wouldn't be here. In those circumstances, we say that respect for any private correspondence was shown, and this court should not develop the tort of privacy to go beyond what Article 8 requires. Further,
Sorry, Ms. Rogers, I think, will say to that, well, that's a stage 2 inquiry. We're only concerned with reasonable expectation of privacy at this stage.
my Lord, my response to that is the learned judge considered and was entitled and right to consider at stage 1. The only matter put off to stage 2 was the question of iniquity.
And therefore you say both stages 1 and 2, but for bar iniquity,
Bar iniquity
were in play at
were
this
before
trial.
him, exactly. And indeed, he dealt specifically with the question of respect, because he had evidence about it, and he found it was a matter that was in dispute between the parties as to whether the defendants had done the right thing. He held that they had, and that they had acted entirely reasonably. So we say that Mrs. Brake was in effect put on notice that if she did not take her personal correspondence off the inquiry's account at that stage, it would be accessible and could be looked at by the Guy parties. Put another way, unlike the employees in Copeland and Halford, there was a warning, and Mrs. Brake could have used that warning to remove material from the inquiry's account before the Guy parties started looking at it.
Before that offer was made, was there a reasonable expectation?
No, we say no. That's our overarching defence to which I will develop. Mrs. Brake did not take that opportunity, and whatever her actual expectations, we say that she cannot have had any reasonable expectation of privacy in respect of the disputed documents, having been given that opportunity.
Well, any reasonable, I think you would have to say, picking up your answer to my Lord Justice Baker's question, that she didn't have any reasonable expectation of continuing privacy.
Exactly, my Lord. I'm not conceding.
No, I follow.
She had one, but you're right. So that's a further stay. But if I can just address you on the way in which this case has changed, from the time that the claimants applied for the interim injunction in September 2019 until the time of trial in November 2020, the foundation of the Brakes case was that the inquiry's account was owned by them, not by the Guy parties, and that it was also covered by confidentiality. The Brakes argued those 2 points should be given near decisive weight in the analysis. And indeed, it was on the basis of these 2 points that the Brakes sought to overcome the multiple users obstacle. On this appeal, my learned friends who didn't appear at the trial rightly do not pursue the ownership argument in respect to the inquiry's account, and the confidentiality agreement point has also been abandoned.
Well, the judge found against Mrs. Brake on facts on that.
He did, quite rightly so, and in her written case, my learned friend ran a different case for the Brakes, which in large part focuses on events that took place after the termination of the Brakes' employment. It's in her written case. It's not clear to us whether that case is still maintained. But in any event, if I could just deal with that case, it has 5 essential problems. First, it isn't the pleaded basis for the claim. Second, it cherry picks from the trial judgment and ignores the evidential difficulties that meant the Brakes did not meet their burden of proof at trial. Third, it is simply wrong in its reading of the judgment. Fourth, it has a fundamental timing problem because post-employment events are irrelevant to reasonable expectations of privacy, confidentiality accruing during the course of employment, which is what this case is actually about. And fifth, it provides no answer to the multiple users question. Now, on her feet this morning, my learned friend focused on the personal nature of the emails that the defendants say were evidence wrongdoing. We say that the problem with that case is that it asks you to treat one factor, namely the content of the emails, as decisive and find that the trial judge was clearly wrong in taking account of all the other factors to which he refers. The position taken by the Guy parties has been consistent throughout the proceedings. We made two principal submissions in closing submissions at trial, and I repeat them again on this appeal. The first is, even though there may have been some emails of a personal nature in the inquiries, we have always maintained that nothing in the inquiries account was private or confidential in law against the respondent. And can I ask you to go to the trial judgment? That's tab 7, page 173. Sorry, page 183. And
Page
page 183.
183.
And you'll see a section beginning pleaded cases at paragraph 193.
Yes.
The trial judge then sets out the relevant parts of the statements of case between 194, paragraphs 194 and 196. And for now, could I ask you to turn on to page 187 and read the summary at paragraph 197.
Yes.
Now, our position, as summarised by the learned judge here, was called the overarching defence. This is essentially ground 1 of the appeal, insofar as it concerns privacy, and ground 3 of the appeal, insofar as it concerns confidentiality. And second, we say that at trial, the Brakes failed to discharge the burden of proof that the disputed categories of documents within the inquiries account were private or confidential, or even actually personal in nature. That is because they failed to put evidence to the court about those categories of documents. With very few exceptions, the court was taken to none of the disputed documents at all. I call this the burden of proof issue, and it maps onto ground 2 of the appeal. So for those reasons, we say this claim failed twice over at trial. It failed on the overarching defence, it also failed on the burden of proof issue. And put another way, even if the Brakes had succeeded on the overarching defence at trial, they would still have lost on the burden of proof issue. And it follows that in order to succeed on this appeal, my learned friend has to succeed on grounds 1 or 3, and also on ground 2 of the appeal.
And what about the list of issues with categorised documents?
That's what I come on to
Right.
deal with that. That's under issue 2. Put another way again, the grounds of appeal are cumulative, not alternative.
All of them? Well, is it 4 or 1 to 3?
1 or 3 and ground 2.
4 is discrete.
Oh, sorry. 4 is discrete. I'll take that as part of a round. So with that introduction, I make my submissions under 3 main heads. First, I need to correct some important errors in my learned friend's written submissions. Those corrections provide the foundation for my later submissions, so I make them at the outset. Second, I will deal with ground 2 of the appeal and the burden of proof issue. And I deal with that next because it appears first in the judgment and so provides the relevant context for the trial judge's later determination of the overarching effects. And although ground 2 is framed as being about privacy, the burden of proof issue is equally relevant to the confidentiality claim. And by not showing the court the disputed documents, the Brakes gave the court no basis for ordering the injunction they sought over the disputed documents on the basis of either privacy or confidentiality. And then thirdly, I'll turn to the overarching defence and address grounds 1 and 3 of the appeal on that basis. And finally, under sweep-up points that I make at the end, I'll briefly deal with ground 4 of the appeal. So turning to the first head, we say there are 7 important errors which appear in my learned friend's appeal status. The first, starting with my learned friend's skeleton argument, which is behind tab 2, at page 71, paragraph 17, you will see that my learned friend argues that the Guy parties accepted in the course of the litigation that 5511 emails were private. That is not correct. My Lord Justice Lewison, I think, has this, but it conflates the concept of personal with the concept of private. There were 5,500 emails agreed to be of a personal, non-business nature, in which the respondents had no interest, and so agreed to destroy them as a pragmatic compromise.
The judge said, didn't he, that you accepted they were private in the passage we're going to come to.
That's why I need to show you, my lord, because this developed, I think he slipped into the use of the word private there, but in fact, as I shall show you, he accepted that we never conceded that, and we always said it. And there is a distinction. I've already shown you the pleading case, which made clear that our overarching defence, that nothing in the inquiry's account was private, whatever the personal nature of the communications. And there are also a few other documents you should see. This argument was put to the trial judge when first seeking permission to appear. And if I can ask you to go to tab 9, at page 238 behind tab 9. This is a transcript of the hearing on the application for permission to appear. And if I can ask you to look on page 238 and at the foot of page 39, internal page 39, you have where my learned friend says on the last line, so our starting point is that it is wrong. You see that?
Yes.
If I could just ask you to read from there down to line 12 on page 41. I ask you to note in particular what the trial judge said in response to this argument at lines 7 to 12 on page 41.
Yes.
He made clear that no admission of privacy had been made in respect of these 5,500 emails. That is entirely unsurprising. He had not seen any of them, so he was not in a position to find that they were private, and we never accepted that they were. The learned judge refused permission to appeal on page 246 in the same tab. And you see he dealt with it very briefly there at internal page 71, last line, line 25, just through to line 5 of the next page, saying he was going to give reasons to follow. And those reasons appear in a judgment that he gave on the 19th of April of last year, and they begin in the next tab at page 293.
Yeah.
You will see that at 294, this argument is recorded at the top of page 294 in paragraph 8.1 in the first 4 lines. He says, just before he goes to 8.1, he says there are 4 grounds of appeal, which I've read in detail, but summarise as follows, and it's the first 4 lines of that paragraph 1. And the learned judge then dismisses this point at paragraph 10, at the foot of the same page, which I ask you to read, focusing on the sentence, first, the problem for the claimants. If you could read the whole paragraph.
Yes.
So the 5,500 emails that were destroyed were not agreed to be private, and they were not found to be private. And the last observation to make on this first point is one about timing. The fact that the Guy parties agreed to destroy these emails in 2020 cannot be relevant to any reasonable expectations which the parties had during the course of Mrs. Brake's work for AAL between 2016 and 2018. And I'll develop that point a bit later. The second error is that in the Brake's unagreed chronology, and this is in the same bundle behind tab 5, at page 118, they say, at page 118, 4th entry down, that the inquiry's account was set up in 2012. That is simply wrong, and it also elides an important distinction between an email address and an email account. The inquiry's email address was set up in 2011, not 2012. But the inquiry's account was not set up until the 15th of August 2015, after AEL was incorporated.
The inquiry's address, did you say?
Yes.
In 2011.
Inquiries at axnola.co.uk, set up in 2011, but the inquiry's account was not set up until 15th of August 2015. And the distinction between an email address and an email account was an important building block in the judge's reasoning. Can I ask you to go behind tab 7 to the judgment and to read paragraphs 42 to 44 of the judgment, which you'll find at 146 and 147. Then on the 2011 email address, can I ask you to read paragraph 55 of the judgment on page 149? The italics are the judge's emphasis. The point here is that the inquiry's email address was at this stage limited to a Google Mail account, not a Microsoft Exchange account. In contrast, the inquiry's account was set up 4 years later, in August 2015, after the incorporation of AAL, and that is a Microsoft Exchange account. And I think I referred, my lord, a lady, to that this morning, in paragraph 77 of the judgment. Can I just remind you of what the judge said there? At the foot of page 154, going over to 155.
I'm sorry, paragraph again?
Paragraph 77 at the foot of 154, my lord.
Thank you.
And actually, while you're reading that, if you could go on to read 78. It was a point made by my Lord Justice Baker as to whether there were separate email accounts.
Yes.
And the answer is yes, there were. There was one email account per email address. And to make that good, can I just ask you to go to Supplemental Bundle 1?
One email account per email address.
Per email address. So Inquiries had its own account. Allo had its own account. Andy had its own account. And the fourth, I think, was Rebecca.
Was there a saffron as well? Somewhere I've said there was a saffron.
You're right, it may have been saffron, but I'll just
But
show
this
you.
is all post, this is what happened in 2015.
This is what happened in 2015. I just need to show you in Supplemental Bundle 1, Tab 2, the document that we have at page 6. And you will find at page 6, behind tab 2, an email from Andrew Allen, the 7th of August 2015, to Allo Break, subject new emails, fast host. Tab 2, page 6. And in the third paragraph, what Mr. Allen says is to add 4 proper Exchange server-based email accounts, 25 gig of business class storage, and then he tells her what it will cost. The third error.
So just, I'm sorry if I'm being slow, but just be clear about this. The inquiry's address existed pre-2015 via the Google account.
Yes.
And it was, whatever the verb would be, transferred over. Was it transferred over, or was it a new address given?
Well,
bearing the same name.
my lord, the learned judge deals with this because there was evidence given as to whether or not there were whether there were emails that used that email address. I think.
He said there weren't any emails before 2015.
No, I think there might have been one.
Yeah.
But the evidence was very.
Well, there was evidence of one.
Yes, yes, and so we don't know quite what Mr. Allen did, but what he did was he linked that inquiry's address to the Microsoft Exchange account, and that was when all these emails started to come in, and that was to an AEL account because by that time AEL had been called Sarafina.
He said it started to come in, but I don't think that in the light of what the judge says, that means that there was any migration over. There was only one email beforehand that anyone could trace.
My lady's quite right.
I just wanted to be
my lady's
There was
quite
no migration.
no, no, that's absolutely.
So my word was the architecture. So the architecture of the structure of the email arrangements from 2015 onwards was 5 separate accounts, inquiries plus 4 named.
Oh, I think from this evidence it's only 4.
4, okay. Not
Inquiries
not
plus 3.
Okay.
But I
Never mind.
I don't want to
Inquiries
go
plus
beyond the
certainly 3.
Yes.
And hosted by fast hosts.
Yes.
hosted by Fast.
Not Google.
And Mrs. Brake had her own Gmail account as well.
She did. So the third error, my learned friend submits that the judge gave, and this is her word, decisive weight to the ownership of the inquiries account. She makes that submission in paragraph 21, subparagraph 1 of her skeleton at page 74 behind tab 2 of this book. That is not correct. Contrary to what my learned friend now claims, when the learned judge rejected the Brake's ownership claims at trial, he expressly said that this was not decisive. So to make that point good, can I ask you to go to behind tab 7, the judgment at paragraph 191 on page 182. And if you could kindly read that paragraph to yourself. It's really starting in the 4th line.
Yeah.
I'll come back to the Immerman quote shortly. Can I also ask you to
Presumably
turn to the-
is relevant.
It's relevant, but it's not to say it's a factor.
Context.
Yeah.
It's a factor.
Part of the context.
It isn't decisive, as my learned friend suggests, was
No.
the way that the learned judge
I mean,
treated it.
if you write in my notebook, you have less expectation of privacy than if you write in your own notebook.
Yes, exactly. Can I ask you to turn to the judgment where the judge gives his reasons for refusing permission to appeal? That's behind tab 10, at page 295. And I ask you to read paragraph 11. I think we read to the end of 10. If I can ask you to read paragraph 11.
Yeah.
The fourth error is my learned friend says that the employees other than Mrs. Bray had, and I quote, limited access to the inquiries account. You will find that phrase twice in her skeleton argument, first at paragraph 21, subparagraph 3 on page 74, then again at paragraph 22 on page 75. And she repeated that claim this morning. This appears to be my learned friend's only real answer to the multi-users question. But this limited access submission has no basis whatsoever in the findings of trial. In fact, it's contrary to the findings at paragraph 231, last sentence, which I asked you to look at in the course of my learned friend's submissions. That's page 198, paragraph 231, last sentence. That's dealing with Mr. Windus, where the learned judge held, and I quote, that Mr. Windus had unrestricted access to the inquiries account. Plainly, Mr. Windus could not have had limited and unrestricted access to that account at the same time. The fifth error is that my learned friend says AEL did not have access to or control over the inquiries account or its password. That's paragraph 21, subparagraph 1 of her skeleton at page 74. Again, she repeated that point in her submissions today. Even if that were right, it is not determinative, as we saw a short time ago from the Immerman quote referred to in paragraph 191 of the judge's trial judgment. However, that argument is also wrong for these reasons. First, the starting point is that AEL is a company, and although the inquirer's account belonged to it, it can only act by its human agents. In this case, 3 of its employees, including one of its directors, had access to the inquirer's account. Second, Mrs. Brake had the password to the inquirer's account, not in her personal capacity, but in her capacity as AEL's employee. No challenge is made on this appeal to that conclusion in the trial judgment. So Mrs. Brake's possession of the password amounted to AEL's possession of the password.
What was the paragraph number in the judgment where the judge makes that finding?
My lord, can I
Come back to us with that.
In our submission, it follows that my learned friend is wrong to contend that Mrs. Brake, but not AEL, had the password. That error arises from ignoring the capacity in which Mrs. Brake was found at trial to have held the password. He found she did not hold the password as a principal in her own right, but rather as an employee and agent of AEL. Mr. Day, helper, reminds me it's at page 219 behind tab 7.
Thank you.
And it's the judge's answer to issue 7.
Issue 10.
Issue 7.
7.
Yes. Do you have that?
It doesn't quite go there, does it?
There's a reference back to 240.
Then, 240 and 241 are, I believe, where he deals with it in. Yes, it's where at 240.
Well, he says, once Shedington became the proprietor, those who hold the keys to the company's secrets were bound to cede them to the new owners on request.
Yes, that's right. And then a bit lower down, he says the fact that Mrs. Foster did not ask for those keys, neither did Dr. Guy when he first bought the company, are irrelevant.
Well, he doesn't quite put it on the agency basis that you have put it, does he?
He puts it, I think, more well, on the point that she was an employee. So it wasn't her hard password. It was the company's password. The same is true of Mrs. Holt and Mr. Winders. Their unrestricted access to the inquiries account constitutes AEL's access to its own email account. If I can then ask you to look at paragraph 110 on page 163. where learned judge found, you see towards the end of that, it was the answer to my Lord Justice Baker's question. The learned judge found that Mr. Windus was entrusted with the password to Allo, and my learned friend said on instructions it was the same password for all the accounts. And then the further point is that AEL also had access to the account through Allen Computer Services, or ACS, which it engaged to administer the account. And this, we submit, is the equivalent of the IT administrator in Simkin. It was ACS which ultimately controlled the account through the ability to set or reset the password, as in fact happened at AEL's instruction after Mrs. Brake's dismissal. And ACS was contractually required to act on the instructions of AEL in respect to the account, no one else. There's now no dispute that AEL was entitled to instruct ACS to change the password on the inquiry's account. We addressed this point fully at paragraphs 111 and 112 of our closing submissions from trial. And I would ask you to look at Supplemental Bundle 2, tab 4, and it's pages 157 and 158. And if I could just ask you to read paragraphs 111 and 112.
Yes.
And sixth, and I can take this next point fairly quickly, in her skeleton argument, my learned friend says there were no relevant contractual terms in this case.
Sorry, there were no
relevant contractual terms in this case. And you find that assertion at paragraphs 5 and 24, subparagraphs 2 and 3 of the skeleton argument. That's on pages 67 and 77 behind tab 2. That is incorrect for two reasons. First, there were relevant terms in the employment contract. I know you looked at this briefly this morning, but can I ask you to go to the judgment in behind tab 7, page 200, where it dealt with the paragraph 241, and to read the second sentence of 241. And then the list of issues at page 219 and 220. And it's issue 11, subparagraph 1, where his lordship says clause 16 is a factor. And for your note, you'll find clause 16 of Mrs. Brake's employment contract at supplemental bundle 1, tab 4, page 17.
70
17.
17.
And in the list of issues at page 2.
At page 220, top of page 220, my lady.
Thank you.
Starts at 219, foot of.
Answer to question 11.
Exactly.
Thank
11.1. And then second, there were also relevant warranties in the sale and purchase agreement, which had been negotiated by Mrs. Brake, ostensibly on behalf of Mrs. Foster. As you know, we allege Mrs. Foster was a nominee, in fact, for the Brakes. And for your note, the judge dealt with this at paragraphs 101 to 108 of his judgment, at pages 160 to 162. So 101 to 108 of his judgment, and then at issue 11.2, also on page 220.
Yeah, that goes to the ownership of the account, doesn't it?
No, I think if one looks at what the learned judge says at
Oh, it's
101.
in answering the questions, in answering 9 and 10. Yeah.
Yes. And he deals with it fully at paragraphs 101 to 108.
Yeah. When clause 16 refers to confidential information, one would have expected that to mean the employer's confidential information, not the employee's confidential information.
Well, anything, it relates to the password.
Oh, yes, it may, no doubt it relates to the password. And it no doubt relates to the account, which belongs to the
yes,
employer.
yes.
It's not obvious that it relates to material which would otherwise be confidential to the employee as against the employer. That would be a rather strained reading of that clause.
My lord, certainly I can see the force of what you're saying in relation to the construction of the contract, but we relied on this for the password point.
Right.
And so seventh and the final point, the final error is at paragraph 11 of my learned friend's skeleton argument, where she says at the first trial, and I quote, the court was concerned only with the first stage of a privacy.
Yeah, well, we've seen the order, which sent everything to trial apart from iniquity.
Exactly. And we just take it, you're quite right. We've given you the relevant references in our skeleton argument, paragraphs 24 and 50, pages 94 and 102 of the bundle. And you can equally see the point by looking at the agreed list of issues at the end of the trial judgment, which clearly goes beyond stage 1 of a privacy claim. And the second point is this, that iniquity also had relevance to the stage 1 issues. The learned judge dealt with that point in his judgment at paragraphs 236 and 237, which is at page 199, which I would ask you to read, 236 and 237. No, you did look at these.
Yeah.
That's more.
Well, can I put to you the same question I put to Miss Rogers? What about the investigation of the question of whether there has been wrongdoing? Well, leave aside the outcome of the investigation, but let's suppose that there are reasonable grounds for investigating.
Yes, and I can take it, you'll remember the reference to where Mr. Darcy approaches Dr. Guy some 10 days or whatever afterwards, after the dismissal, and he considered he did have grounds.
Yeah.
Our solution is that in those circumstances, the defendants were entitled to investigate.
So the court, when the judge says in the second sentence of 237, the court cannot decide that without first examining whether there is any evidence about wrongdoing.
Yes, my lord,
Right.
we would accept that, as the judge explained here, where the documents were said to evidence wrongdoing, the court could only reach a provisional view in relation to that on reasonable expectations of privacy. Obviously, that's why they're accepted. If he hadn't accepted our overarching defence, then there would have to be a second trial in relation to wrongdoing.
Of what? Whether there was in fact wrongdoing or whether there were reasonable grounds to investigate wrongdoing?
Well,
Because I'm only
Yes.
concerned at the moment with the second. What if there are reasonable grounds to investigate, and let it be supposed that after investigation it turns out there wasn't any wrongdoing?
well, my lord, on that, I respectfully submit that the defendants were entitled, if they had reasonable grounds for investigating, they were entitled to investigate. And if they weren't, if those grounds were not reasonable, or found not, if having conducted the investigation, they discovered there was nothing to confirm those suspicions, those reasonable grounds, then that would be a different matter. But that was not, and the position here was that having done the investigation, the Guy party said that there was indeed evidence of wrongdoing. And where we say the judge was entirely right is that question could not be determined whether there was wrongdoing until the second stage. But what we do submit is that the defendants had reasonable grounds for the reasons the judge gives in his judgment for conducting an investigation. Yes. The point is that at this stage, all that we needed to satisfy the judge was that there was a prima facie case of wrongdoing. And the question as to whether there actually was would be determined at the second trial. So, for those reasons, we submit, with respect, that my learned friend is simply wrong when she suggests that the first trial mapped neatly onto stage 1 of the test for privacy. It did not. And my learned friend suggested this morning that the split of the issues that was decided on in this case would never work with iniquity carved off. But what, and respectfully, she wasn't dealing with at the time, so she may not have fully appreciated this. But that was a split which the breaks themselves sought. And if I can ask you to go to supplemental bundle 1, tab 13, and it's page 151. Where at the top of the page, paragraph 4, the learned judge explains in his reasons that the claimant's secondary case is even if the iniquity base were available to defendants as a matter of law on the assumed facts, the defendants would have no such defence. Accordingly, if the summary judgment application failed, they asked for an order this issue be tried as a preliminary issue. This was in the evidence rather than the application notice. So it was at their request, the learned judge declined to deal with it as a matter of summary judgment for the reasons he gives. But it was at their request that the preliminary issue on the iniquity point.
That's the question of law, is it?
That's right. The point is that we submit it's simply wrong for the breaks now to say the split was inherently unworkable when it was the directions that they sought. They have to live with it.
Is there a difference between what the judge said in the preliminary issue judgment about how he was going to treat these issues and what he said in the main judgment? And I'm comparing paragraph 40, which is on the authorities bundle 2, type 21,
Yes.
with what we were shown in paragraph 190. We compared and contrasted it with paragraph 190. And I'm just now looking at that in the context of paragraph 236, which you were taking us to a moment or two ago.
Yes, my lord, in my respectful submission, there isn't. He amplifies the position in his trial judgment, but there isn't, in fact, a tension between the two. He deals with it shortly in paragraph 40, but the way he dealt with it more fully in the judgment is perfectly consistent.
Well, 140 he says, sorry, 40 he says, and also injunction that it matters there is at least a two-stage test, and that the iniquity defence does not come into play at the stage of considering whether there was a reasonable expectation of privacy, so that the information was private, but also at the only at the subsequent stage of considering whether there was any justification for the use made or proposed to be made. And then at 236, in the main judgment, he introduces objectivity, and then says this creates difficulty in cases where, like this one, the first and second stages have been split. Whether there is a subjectively appreciated expectation of privacy can be determined at the first stage, but whether, if a subjectively appreciated expectation is so found it is reasonable, will potentially be affected by, for example, whether the information concerned was known by the claimant relevant to the question of commission of wrongdoing. So is there a difference there? I mean, the paragraph 40 seems to say that iniquity is only relevant after it's been established as a reasonable expectation of privacy, whereas 236 seems to say, doesn't it, unless I'm misreading it, that the question of iniquity is relevant to the reasonableness of the expectation.
Well, my lord, I quite understand why you asked the question. I think the difficulty with paragraph 40 of the earlier judgment is that what his lordship is there dealing with is an argument raised by Mr. Stephen Davis QC, who is then representing the Breaks, and answering that. He gives a much fuller, considered position there in paragraphs 236 and 237. Where he states the position in law, we submit entirely correctly. And looking at paragraph 40 of the early judgment, he's dealing with, when one reads the judgment in context, he's dealing with a submission.
I haven't got here in my head what 140 is a response to something else.
It's a submission made by Mr. Davis, you see, as a matter of law, and he's responding to it.
On
there.
some point, I haven't got my head round. Anyway, you say, do you, that he was right in what he said at 236?
Exactly, and 237. So, my Lord Cook and my Lady Cammer, I move on to the burden of proof issue, which is ground 2, my second head. And this issue begins with the trial judgment at page 175 of the bundle, paragraph 164. And it's a point worth making. I do not understand my learned friend to be challenging any part of the first 163 paragraphs of the trial judgment. If I can pick up the analysis now at paragraphs 172 and 173 on page 177, the learned judge is here dealing with the first disputed category of emails comprising 3149 emails, what we call the personal business, the disputed personal business email, at paragraph 17 of our skeleton argument. We thought that category was conceded this morning, but it appears from what my learned friend said after the short adjournment that it's not, so I can deal with it briefly. These are emails which the breaks say were personal, and the guy parties say are business emails. The status of these emails was to be finally determined at the trial. That's because they had nothing to do with the iniquity defence, which was the only issue deferred to a second trial. The evidence as to the breakdown within this category is summarised in Appendix 2 to our skeleton argument. Could I ask you to go behind tab 4 and find page 116? And when you have 116, it's that what we're talking about, the 3149, are in the top half of that. And this is drawn from the evidence of the solicitor with conduct of the review for the guy parties.
Mr. Spendlove.
That's right.
This is Spendlove 3, is it?
It is. And it may be Spendlove 2 as well, but it certainly was his evidence. None of those categories on the face of it is personal to the breaks, and the breaks adduced no evidence to the contrary. You'll see that the largest single subcategory are emails relating to the business's social media accounts. That's 1,191. Mrs. Brake herself appeared to disclaim a claim to induct those emails at trial. And if you can just go to page 178 of this bundle, you will find paragraph 175, where his lordship addressed this in the last 3 sentences of 175. You see where he says one of these categories was 1191 social media emails. These don't have the necessary quality of confidence. It doesn't appear that my learned friend has yet made the same concession as Mrs. Brake did in cross-examination, but perhaps she will do so in reply. We don't understand if an injunction is still being sought over those documents, and if so, on what basis. But if we can move on to paragraph 178, which is on page 179 of the bundle, where the judge concludes in 178 that the Brakes have not discharged the burden of proof in showing any documents in the disputed personal business category were personal, other than 2 documents put to Mr. Spendlove in cross-examination, which were destroyed. And in my submission, the conclusion the trial judge reached in this regard is unarguably right. The judge had only been shown 2 of the 3,149 documents in dispute. He'd not been shown a sufficient number of the documents to accept on the balance of probabilities that all these documents were personal. This court has not even seen the 2 documents which the judge saw, and yet is asked to reach a different conclusion on the burden of proof. With respect, it's impossible to see.
But was any attempt made, and or was it possible to map descriptions in Spendlove 3 onto the list of agreed categories in the list of issues? They are described in very different ways.
Yes, and I come on, if I can answer my Lord's question by reference to what I'm going to say about those categories. But
yeah,
the short answer is no. No attempt was made. But my Lord, the judge's approach, we say, was entirely consistent with the principles identified in Brown and associated newspapers, to which I referred to at the very beginning of my submissions. And it is just worth reminding you of what Master Lord says in Brown behind tab 5 at page 99, paragraph 32. If I could ask you to read paragraph 32.
Of Brown.
Of Brown.
Remind me again where it is.
It's page 99 in Authorities Bundle 1.
Sorry, which paragraph again?
Paragraph 32.
Well, that needs to be qualified in light of Immerman to some extent, doesn't it?
No, my lord, I don't believe it does.
Well, what they're saying in Brown is the test must be applied to each item of information, and in Immerman at 78, they say you haven't got to identify each and every document.
No, my lord, I was just going to come on to that point. I need to make it clear that despite my learned friend's submissions to the contrary, at paragraph 28, subpart
Well,
1,
you weren't asking each and every document to be identified, and I think the judge makes that clear in the course of his judgment. He says that specifically.
That's right.
All I'm suggesting to you is that the apparently unqualified statement in Brown needs some qualification in the light of Immerman, as I think recognised in your submissions to the trial judge.
Yes, exactly. I do accept that. I do accept that. But can I just show you how the point was put in closing? In our closing submissions, and this is supplemental bundle 2, tab 4, page 110. If I could ask you to look at, or to read.
What are we looking at?
Page 110.
110, yeah.
If I could ask you to read paragraph 5,
8.
Well, 5 little 2, which is where
Yeah.
submission from Mrs. Brake is a straightforward case, and we deal with that second submission, 5.2 at paragraphs 8 and paragraphs 9.
Yeah. Yeah, well, that's reflected in what the judge said at paragraph 175.
That's right, and we dealt with it in more detail, just for your note, under the heading the disputed documents at pages 133 to 135, paragraphs 62 to 70. Because the appellant's counsel at trial then ran the same argument that my learned friend now makes, together with the additional submission that a further hearing was required to deal with any specific emails. I'm not sure whether my learned friend goes that far, but in any event, our responsive note, and this is behind tab 6 in the same bundle, page 176, deals with this. We pick up the point at paragraphs 3 and 4. I've read, you've read paragraph 4.1 already. Can I ask you to read paragraphs 4, subparagraph 2 to 4,
Yes.
and then 6 and 7?
I'm sorry, can you give me the page number again?
So sorry, my lady. It's behind tab 6.
Yes.
And it's the first page behind tab 6, 176.
Oh, thank you, I got it.
And it goes over to 178. And finally, I need to show you how the...
I see how your submission works on the ones that were disputed, this category you've been dealing with, where Mrs. Brake says they're private, the Guy parties say they're not. I see. The judge has to decide, and he will need some material on which to decide that disputed question of fact. But what you're addressing in the paragraphs of the submissions you've shown us is a slightly different question, which is that you say it's not open to Mrs. Brake to assert that a particular category of document is private without some evidence of what is in that category. But go back to the question of medical records, for instance. Do you say you would need to show the court that there are medical records, or what they are, before the court could be satisfied that medical records are private?
What is preempted by next submission, which is that, so I think in relation to these disputed ones, don't need to...
Well, I see that, because there's a disputed fact.
and
Are
your
they
lordship has-
private or not?
Exactly, your lordship has what the learned judge said at paragraphs 175 to 178 of judgment. Can I now then deal with the answer to my lord's question? And for this, it's necessary to go back to what we're talking about, which is in behind tab 4 of the core bundle. And to look at the second half of that page 116. This is appendix 2. Now, my learned friend repeatedly referred to medical and school emails this morning. There's no medical documents in this category, and the only school emails relate to the fact that the Brakes were paying very expensive school fees for their son whilst bankrupt, which prima facie constituted evidence that they were hiding income or assets from the trustee in bankruptcy. and they were passed for that purpose to the trustee in bankruptcy.
So, the evidence of Mr. Spendlove is this. I've broken these documents down into this category. There is no specific category there of medical records. So you would say what? The burden was on the Brakes to show,
Yes.
Mrs. Brake, to show that somewhere amongst these categories there were medical records which could properly be said to be private, and that wasn't done.
My lord, that's right. All the medical emails were deleted. They were within the 5,500 emails.
We saw a breakdown somewhere else in the papers. I'm trying to remember where it was, where medical was mentioned. It was another table. We were shown this morning.
I think it's in the list of issues, isn't it?
Is it in the list of issues? I don't think.
Well,
I'm trying to remember
Was
where it was.
the 1 to 16 and it was in the 1 to 10.
No, it's not that.
it's in supplemental 1. I think my Lord Justice Baker's referring to supplemental 1, tab 21.
That's Mr. Spendlove.
Yes.
Does he talk about medical?
Yes, 228.
Well, I think it's 223, isn't it? It's issue 12.4, correspondence with the Brakes medical profession.
That wasn't that. I was thinking of a table. Yes, it's the table on 228.
228, which is
Well, that's all that's all agreed. I see.
agreed to be destroyed.
Okay, so that's all gone. Right, forget about that.
So we said it wasn't. We simply weren't interested in those medical records, and it wasn't an issue at the trial. So and the school emails were only relevant because of the
Okay.
reason I've explained.
Well, I would hazard a guess that P.R. Williams Legal might be legally professional privileged.
No, because funnily enough, he'd been struck off at the time, and so they weren't.
Mitchell Moores are solicitors in the West Country.
They are, but in any event, there was the same in the second category. Can I just take it? And I'm conscious of the time. I want to take you to the trial judgment first, where the relevant part of the judgment begins at paragraph 179. At page 179, this is the right reference.
179, yes.
And again, I understand that there is nothing in paragraphs 179 to 185 which is challenged. And the central point is that only 11 of the 4,849 documents in this category were shown to the court at trial. And the judge concluded at paragraph 186 on page 181 that he had no evidential basis on which to conclude that the remaining 4,838 documents did not evidence wrongdoing. So
Well,
these documents...
I'm sorry, he starts by saying that he's in no position to decide they're private. Never mind wrongdoing. First sentence
Yes,
of
you're quite
186,
right.
he says he can't decide that they're private.
They're private, you're quite right. So the position in relation to these documents is that if this court were to conclude that the overarching defence should have been dismissed by the trial judge, and I'll come on to that, then only then, in other words, if ground one of the appeal is successful, those documents would need to be considered further in the iniquity trial.
But in 180 and 181, he does seem to be accepting that those documents are private, but they are subject to possible iniquity defence.
Yes, my lord, that's right. Can I move on? I think I'll be able to deal with this in the time available for court. Right?
And when he says, just to be clear with this, when he says these three documents, bottom of 180, are private on their face, the last sentence of 180,
Yes.
he doesn't mean that there's a reasonable expectation of privacy.
No. No.
He's using private on its face to mean, as
you.
you have used, personal.
Yes. And but they contain information which may bear on the unlawful scheme retained on that basis.
Well, Mr. Sutton, if we were going on to a new point, I think we can do that tomorrow.
Well, certainly, my lord, if you prefer, I was actually going to deal with the third category document, which I can deal with relatively.
All right.
I thought that had been abandoned, but it appears not. Those third category documents, the judge dealt with those. If you've got page 181 open, at paragraphs 187 to 189 of his judgment. Now, his analysis in those paragraphs hasn't been challenged by my learned friend in her written submissions, nor, as we understand it, in her oral submissions. But for your note, we addressed these at paragraphs 15 and 16 of our skeleton, which is page 92 behind tab 3. Now, these were documents which the breaks accepted were not purely personal, but nor were they just business related. In the month before trial, the breaks indicated that they didn't maintain their claim for an injunction over any of these documents, and the letter for your note, again I don't need to turn it up, is at Supplementary Bundle 1, tab 18, page 210 is where the letter starts, and the relevant paragraph is paragraph 9 on page 213. Now, at trial, having sent their letter through as solicitors, they then changed their position again and sought final injunctive relief. Like the first category of documents, the status of these emails was to be finally determined at the trial. That's because they had nothing to do with the iniquity defence, which was the only part held over to the second trial. And the important point is this: not a single document from this category was shown to the judge at trial, and at paragraph 190, if you have, can turn over to page 182, at little 3, the judge made clear he felt unable to order a final injunction in those circumstances, whatever the position on the overarching defence. And in our respectful submission, this court's no better position than the trial judge in respect of the evidence. And you've no real idea what these documents are or why an injunction will be justified in respect. That was all I proposed to say on that.
Right. So that's the first two heads, is it, of your submissions?
I just had some brief submissions to make in response to...
So you pointed out what you said, the errors in the appellant's case. You've dealt with burden of proof, and then your third head was your overarching defence.
That's right. And just before, I'm getting to that shortly, but before I do so, I just want to deal with the breaks arguments on this ground 2 of the appeal, which I can deal with very shortly, but I think it's probably best if I don't do that now.
Right. All right. 10:30 tomorrow.